Good afternoon, everyone. If you could come forward and get your seats. All right. Last month, I think it was last month, the Wall Street Journal ran a front page story. Many of you probably saw it. I'm wondering, those that are watching this, if they're watching it on recording or otherwise, if they saw it. And the title of the story was, "When Apple Comes Calling, It's the Kiss of Death." When Apple comes calling, it's a kiss of death. And I was a father with a daughter, she's not here yet, but with problems of controlling these phones. I've got a different iPhone problem. But in this case, this in-depth article gave a very accurate picture of what's called efficient patent infringement. Efficient patent infringement, also known as we refer to as predatory infringement. And the problem, pretty good that the Wall Street Journal had it on there. If you haven't read it, I encourage you to give it a close read. And we don't have copies with us, but I know I have a copy in my office if people need us to pass it around. And what Apple knows, and other of the serial patent infringers know, is that it's going pretty well for them. It is now what we call, and we refer to as, an epidemic proportions. Now, you can't use that epidemic word, Jim, as easily as you could. In the old days, it was more dramatic. Now, everybody knows exactly what it means, but they worry about other stuff. But it's really gotten, every year that we've done this, it's gotten worse and worse. And our program tonight, or today, and then into this evening, the conversation, the title we chose is Patent Infringement, Just Another Name for Theft. Just another name for theft. We don't want anyone to have any doubt what we think of it. It's not a debate. Infringement is theft, and it's theft from someone to someone else. It's a big deal. So I'm Ed Martin. I want to welcome you to this event. I'm very grateful to be here. I'm the president of the Eagle Forum Education and Legal Defense Fund. Someone said earlier, might have been Professore here. No, I don't think it was. Someone said to me, "Thank you for continuing this effort." Phyllis Schalfly believed very strongly in our patent system and believed that it was important that we be here together in Washington, D.C., communicating about that. As I was getting ready to come up here, I heard from one of you about your efforts to speak to legislators, members of the House, and educate them on what's happening. We've got a lot of work to do, but we've got more and more hands in this, and we're really grateful. So this topic, again, this topic of patent infringement, it's an important one. It's timely, and the implications are serious for American innovation and for competitiveness. Whether it's the question of the communist regime in China and what they're doing, or others, they're just infringing, as we talked about with Apple. So we're glad to be here. We're going to have this panel discussion and then Q&A. It'll be led by our fearless Jim Edwards. But I want to say first thank you to our sponsors. Every year we have wonderful sponsors that have been so generous in making it possible for us to do this. So the Biotechnology Innovation Organization, Acacia, I do it every time, Acacia Research Group, the Innovation Alliance, and Interdigital. Their support has made this possible, made it something we do and we can do with energy and excitement. All looking forward to it. We're glad to be back at the Capitol Hill Club. And our leader on a lot of this, and certainly on these events and these issues, is our patent advisor. We call him our patent policy advisor for Eagle Forum Education and Legal Defense Fund, and that's Jim Edwards. Jim will moderate the panel, and this is where I usually say far too effusive praise of Jim, and he doesn't really stop me, so I'll go ahead into it. He's worked up on the Hill in various capacities, but in particular, he has a real gift for bringing people together on this issue and other issues as a conservative, as a Georgia Bulldog fan, and as otherwise an experienced hand. He's been masterful for us. Phyllis Schlafly believed in him and believed in his importance, and we're so grateful for Jim for what he does. So Jim Edwards. Jim, please.
Thank you, Ed. You know that those Floridians from Mr. Posey's office may not be so big on the Georgia Bulldogs.
Yeah, right. Can't resist.
Well, you can prepare a panel and it not work out exactly the way you want. So we're going to go with the flow. I know that our speaker from Centripetal will be with us in a moment. He is on his way, but we'll be right here. I think he just walked in. And so we've got everybody, we should be able to go in order. So The question I want to pose to set this up is, do you suppose that inventors will continue to invent, that investors will continue to invest, or America retain our competitive advantage in innovation if patent infringement remains easy to sell, make, and use other people's things, using their inventions dishonestly? Well, the short answer, you probably guessed, is no. Congress, courts, and the federal agencies have steadily weakened our patent rights. And this has fostered the now common practice of predatory infringement. The problem is that America is paying the price for these changes. And if we continue to weaken our IP rights and enable the infringement by the lack of effective remedies against it, not only is the iconic American inventor going to disappear, the consequences are far beyond that. And so that's what we're going to explore today is our panel will talk about infringement of patents from the standpoint of the academic, that is the table setting on this issue, and then from the perspective of the small company and the large companies, R&D companies, and then what are some solutions? Are there any hope to dig out of this? And so don't want it all to be just rain. We want a little sunshine in there too. So I'm going to introduce our speakers. Each of them has 10 minutes, at the end of which I will give them the hook, and we'll get somewhat course corrected on our schedule. And then we will have Q&A at the end. So think of what you want to ask. And I'll introduce them in the order in which they'll speak. Adam Mossoff teaches patent and IP law at George Mason's Scalia Law School. He's senior fellow and chair of the Forum for Intellectual Property at the Hudson Institute. And at the Heritage Foundation, he's a visiting intellectual property fellow. Adam will give us an overview of what patent infringement is. Stephen Rogers, I should interject that his son Jonathan was scheduled to be here. Jonathan had change of plans, so it's kind of like we had Luke Skywalker lined up, but we're getting Obi-Wan Kenobi. So Stephen Rogers, he's the chief executive officer of Centripetal Networks and founder of Centripetal. He started this cybersecurity company in 2009. Stephen served in the U.S. Air Force. He worked on secure communications and networking there. And Stephen's first startup was built high-performance routers. So this background set the stage for Stephen to be a pioneer in cyber threat intelligence. So Stephen's going to give us the small business, small company perspective on patent infringement. As you may have heard, they've been involved in a little bit of an issue on that. Brian Pomper is executive director of the Innovation Alliance, a coalition of some of the nation's leading R&D companies. As a partner at Aiken Gump, Brian co-leads the public law and policy practice. He's a registered patent attorney. He served as the chief international trade counsel at the Senate Finance Committee. And he'll give the perspective, the view from the large R&D companies, the members of his coalition. And John Schalfly is Phyllis Schlafly's firstborn child, in fact. John worked alongside his mother, not only in Eagle Forum Education Legal Defense Fund, but other of her organizations that she founded. John's an attorney, and he also holds degrees in accounting and engineering. So he's got something to fall back on, right, John? He's going to discuss the legal and policy solutions that we might encounter and can contemplate. So, Adam, you got 10 minutes, bud. Come to the lectern.
Thank you, Jim. Thank you for the invitation to speak, and I appreciate appreciate the Star Wars reference. But if you at 10 minutes, if you strike me down, I will only become more powerful. So. All right. So before I talk about the practice that has arisen in the past 10 or 15 years that policy wonks call efficient infringement, and which is better styled, I think, as Jim called it, predatory infringement, because efficient infringement sounds good. How can you be against efficiency? And this is not a good practice. I first want to set the context of why this is a concern. How did it arise? And so by talking a little bit about what are patents and what it means to infringe a patent. All right. So let me first start though with a very important and auspicious anniversary yesterday. I'm sure you all noted it. You woke up and you you said today is the day. And of course, what am I talking about? Well, yesterday was the anniversary of the patent issuing in 1906 to the Wright brothers for their invention of what they called the flying machine. So these two brothers, Orville and Wilbur, bike mechanics in Ohio from modest means, no wealthy connections in their family or otherwise, right? Solved this problem that had been plaguing humanity for decades, if not centuries, of how to fly. And as all pioneer inventors experienced, they were faced with people who copied their invention. Many people, some of them innovators themselves, but nonetheless they copied their invention and didn't give them credit, didn't pay them the licensing fees that they should have paid. And so they, like all innovators in all of U.S. history, engaged in patent infringement litigation, where they had to sue people to secure their rights to their innovation, their incredible, groundbreaking innovation. I flew back from a conference at UC Berkeley last night, and I actually gave thanks to them on the plane on the way back. And they were protected, and so the courts consistently recognized that these other individuals were infringing their patents and that they should be paid for the use of their property, in which they eventually were. And very importantly, the Wilbur and Orville represent kind of the American dream. We all know them; they're famous, right? They kind of represent, as I meant, what it means to live in America, where anyone, through their use of their mind and through their productive labors, can make themselves better off and the world better off by creating these new innovations. They represented the American dream. Very much like, the American dream in a house. And if someone violates your rights to your house, if someone comes into your living room without permission, you can kick them out. You can prevent them from doing that. If you are a landlord or engage in other types of activities, Capitol Hill Club, if Jim and others just kind of came in here and set up without permission from the Capitol Hill Club, the Capitol Hill Club could kick them out. That would be called trespass. And that's an important part of securing to Americans the dream that we all have to own our own property, to own our own homes and our other assets that we can control and recognize as central to ourselves and central to driving economic relationships. Well, the founders also recognized, and a lot of people don't see this, that patents were to be very much part of the American dream as well. So patents are in the Constitution, as along with copyrights. It's the only area where you actually have federal property rights. The protection of an exclusive right is what Congress has authorized in Article 1, Section 8, Clause 8, to secure to inventors and authors. And the founders did that because they knew that these were the same types of new valuable assets that you might recognize in a home or a farm or a business as inventions and creative works, and that these should be protected to the creators. And they should be protected as property rights. And in fact, they were innovators in that respect. The founders were the very first people who recognized for the first time that these weren't monopoly grants, these weren't special privileges, these were not grants simply because of you're pursuing an economic regulatory policy of some type or other. that, in fact, these are property rights that arise from the productive inventive labors of individuals in the same way that an individual tills the soil and plants the crop and waits for a year to finally create their harvest, that they are secured in the fruits of their labors, that famous metaphor. Inventors should be secured in the fruits of their productive inventive labors when they toil for months, years, decades sometimes, and today in the high-tech and in the biopharmaceutical sectors spent billions of dollars to create the new innovations that have made life in the 21st century a veritable miracle by any historical standard. And so patents represent very much part of the American dream as houses and other types of property, and they are secured in that same way then, as Jim referenced, you are protected in a new invention. And you therefore are protected in how it can be made and used and disposed of in the world. And in fact, the very first Patent Act that was enacted in 1790, I like to point out the first Congress spent weeks debating about what they were going to call President Washington. Do they call him His Excellency, Mr. President, His Highness? They didn't know, but President Washington said to them in one of his first addresses to Congress, pass the patent and copyright statutes, and they immediately did that. In fact, it was some of the very first legislation they passed. The Patent Act of 1790 and the Copyright Act of 1790, and they both secured these core property rights, this ability to acquire new values. You invent something, it's yours, and then you get the ability to have exclusive control, the exclusive right that is defined in the Constitution as to how that's to be used. You can then license, meaning you can embrace division of labor and specialization, and you can recognize that some people are better at manufacturing and some people are better at commercial activities and retailing, and you should just be an inventor. So you can do what Samuel Hopkins did, the recipient of the very first patent in 1790, a patent for making potash. He licensed his invention. And Oliver Evans, the first person to receive multiple patents, I think 5, 6, and 7, he also licensed his inventions. In fact, one of his licensees was President George Washington on one of his patents on a method of operation of a mill. And so when you go to Mount Vernon, you see the mill there, know that was actually employs a patented invention that President Washington licensed. That shows you how much respect they had for this, because he could have just taken it. I mean, who would have sued President Washington for patent infringement in 1793? But he knew that these should be respected and that these should be recognized as the legitimate rights, the property rights of creators. Now, there is a difference, though, in this dream between patents and homes. And when someone comes into your home, you can sue them for trespass, but you can also call the police and have them ejected by the police. And you can and trespass is not just a civil claim between two individuals where you can sue for damages or an injunction, but it's also a criminal claim. The state can bring an action against an individual for criminal trespass. You don't have that in the patent system. The patent system has never provided for criminal sanctions. And so the only way for an innovator to enforce their rights and protect their rights against theft is through patent infringement lawsuits. And this is why every major American innovator, Isaac Singer, Charles Goodyear, rubber, Samuel Morse, the telegraph. I know, for those who know me, I spent a lot of time on these people. They all engage in massive litigation campaigns because people took their property from them. And they were protected and secured in their rights. The patents were secured as reliable, effective property rights, and that's how they drove the American innovation economy. That's why we recognize them as the great innovators they are today. Unfortunately, as Jim referenced, we have spent the past 10 or 15 years in the United States weakening our patent system. There are no longer these reliable and effective property rights that once were secured to the great innovators like the Wright brothers and Samuel Morse. So you have Morse code too. We have made it impossible, next to impossible, to get injunctions for someone who is taking your property. We have created this whole regulatory regime called the PTAB, whose sole function is to cancel patents. And People can file as many petitions as they wish, 10, 20, 30 petitions, imposing costs on the patent owners to cancel their patents with cancellation rates that range as high as 80%. And at one point in one of the programs on business method patents, the cancellation rate was 100%. So this was why it was referred to as a death panel for patents, and that was not rhetoric. I mean, when you have 100% cancellation rate, there's no other better term for that. And so large, well-funded companies, multinational corporations in particular, have figured out that they can exploit these advantages now. So they can't be stopped when they steal someone's technology to use it. And if they are sued, they will file multiple petitions at the PTAB. They also have numerous defenses that have been created by the Supreme Court and others to remove their patents. And so the result is that they engage, from their perspective, in what is a less costly action in the short term, which is to take the property, which is efficient only in the short term, because really what this is predatory practices. This is predation upon innovators, and the fact that they don't have the stable and effective property right protections that we've afforded to innovators in this country, like the Wright brothers, and we should continue to do so today. So thank you.
Thank you. Had to protect against infringement on the clock. Sue me. Call the police. Stephen Rogers is next. Tell us the small company perspective.
That's already got giving up her
Thank you.
open mic. It's very dangerous.
I'm going to turn on my clock here so that I do not infringe this. Oh, good. Okay, thank you very much. The reason I was a little late arriving today is that my ride bringing me into the town, into the city here, we got stuck in traffic and it just got worse and worse and worse. And finally I got out of the car, walked 15 blocks and made it here in time to deliver this speech. Now, the reason why that's important to me is that some years ago, a previous entrepreneurial venture on me, very well funded by venture capitalists, we built routers, and those routers would route internet traffic with perfect delivery and make maximum efficiency of the highways. And the analogy to that is that when you look out, if you took a satellite photograph of all the roads out here, you would see that there weren't actually cars covering every single bit of the asphalt, but instead they're all grouped up around the intersections. And so we discovered that mathematically we could route based on how to get the traffic there faster. And what that meant was that you could build a network with a tenth or less of the capacity, and it would deliver far superior performance for all your apps that you use today. Now, you would think that such an innovation would be really great. We spent a lot of money on it. We built it. We developed it. We worked it. And what happened? The existing vendors of network equipment had a very different idea. They wanted to sell you more and more and more and more. And so they banded up to discredit us and to diss us to all the customers and so on like that. So the reason I mention that is that the thing to understand about innovation is that innovation disrupts. Who's it disrupting? It's disrupting the existing players to the benefit of everyone else. Everyone else would benefit from an innovation. Everyone benefited from the car, the telephone, all these things we know. But the buggy makers, they didn't like it. Okay, so that's what innovation does, and it's really pretty important to understand this. So what happened to our company? So I have a background in security and networking theory and development. I've done 5 startups. I took one public. It was actually the best performing IPO for 1998. Anyway, so a little bit of experience there. And what I saw going on in cyber is that it's getting worse every year. And if this trend has continued, it's getting worse. The amount of money hacked and stolen is worse. The number of people, the scale of the people, the hackers are moving downscale to smaller and smaller businesses and stealing from individuals now and so on. It's becoming a huge problem, okay, which can tear apart the entire internet, because if you can't trust it anymore, what are we going to do? And it's getting worse every year. We have not made progress against cybersecurity. And I discovered something in looking at the problem. And that is that if you look at every major hack that has occurred up till the time when we started our innovation, what we discovered is the hackers, their sources, their methods, who they were all known ahead of time, long before the hack. It was all known. It was in the community somewhere. There was what we would call intelligence about it. And the problem is there was no way to use the intelligence to stop the bad guys. There was no way to apply it. And when we went to pitch our idea, we ran into a buzzsaw of trouble because no one believed that we could actually do that. The amount of computation required at every point of use would be too great. And so we had to develop new mathematics for computer science that would enable you to make faster decisions than you could otherwise do on a normal CPU, even a multi-core CPU. And this was very hard. There's a lot of math behind it. It took us years to get it to work. And it's really amazing stuff. And so when you apply the threat intelligence at the scale that we do, you really don't get hacked. And the problem is largely solved. You get 99.9% of all attempts to take you down are done away with, which gives your team that's left time to look at any straggling things that might be left. It's an amazing breakthrough. It's hugely disruptive. Who's it disruptive to? Well, you can guess the existing powers that be, and they didn't like it. They hated it. They just hated it, and did everything they could to discredit us and so on. And we started taking customers from them, and that's what happened. And then what we discovered is that we were being infringed. When they found that the discrediting approach, the fear, uncertainty, and doubt, don't go with this company, they're small, they're underfunded, they only got $50 to $100 million of venture capital, they can't take care of you, you could get jobs from us when you retire. You know, they have all these techniques. That didn't work. That stopped working. And because people would buy our stuff, they'd put it in, they'd say, this is absolutely astounding. And we've got, we got all across the board types of customers now, international. We're protecting whole countries now. So it's working. So now what do? Well, time to copy. So that's what happened. Infringement took place. And now here we are, a company trying to grow our market and everything, and we've got to deal with this. We've got to do something. And we tried to think of all different ways that we could approach it. Maybe we do better marketing. Maybe we do better other things. And we did those things, and we are doing those things. But in the end, we found that we had to defend ourselves. Okay, that's when we discovered things like the PTAB. Okay, and we had no idea about this, and until we were faced with it. And what we discovered is that the powers that be can file their petition. You know about this well. In our particular case, it's millions of dollars per PTAB filing that we have to spend trying to defend this thing. And you don't get discovery, and you have all these issues that you have to fight. It's almost impossible. I don't see how any small company can deal with it. It's almost impossible. And we just had a reason hearing, and in the courtroom, the whole place is filled up with lawyers on the other side, 40, 50 lawyers. And here we show up. We have a pretty good team, but it's nowhere near like that. So I'm putting myself in the shoes of a small inventor, an innovator. A company may be funded by venture capitalists. How do you deal with that? You can't. We ended up with 17 so far attempts to cancel our patents in the PTAB. So that's a lot. And then we had to do trials. The amount of money spent by the infringers per trial is more than all the money that, that we had to run our company just in lawyers. Okay? So this thing is really, really serious, and it's getting worse and worse and worse. And so now I see it. I see what happened is the infringers, a very highly funded, the establishment, figured out a way to get a thing called the AIM put in place that allows them to continue stealing and not be disrupted. That's what it is. That's all it is. And you might say, okay, so yeah, patents, okay, that's look, America is not a manufacturing power anymore. The manufacturing's been offshore. We're not long ago stopped being an agricultural-based economy. So what have we been? Innovation has been the thing. All of these inventions which powered Silicon Valley and the development from the telephone all on to today, all of these innovations. And now that's coming to a grinding halt because what venture capitalists, we had to undergo all of this diligence on our patents when we raised our first VC money. What venture capitalist is going to invest? Okay, who's going to invest? If they don't know for years later whether that patent will just be canceled just like that. And the reason why, I think we've sustained so many of these things is our innovations are so unique and so great and so hard to say, oh, it's obvious, that we've been able to hang on to many of these things. But it hasn't been easy, and we lose ones that should be stupid. So anyway, what I think we need to do if we're going to preserve the innovation, because innovation is tailing off right now before our eyes. We can see it all over in the types of things and VCs can invest in, won't invest in, fundamental technologies won't invest in anymore. This is going to kill us. You have no idea how much of the money that flows through our pockets today came from some innovation somewhere. That's all going away, and all because of this thing that has been done. So the news is we're calling for the repeal of the AIMA, the repeal of the PTAB. It's a terrible thing. It's a terrible, evil thing that's been done. And I could make your skin crawl with what practices go on inside of this thing. It's a terrible thing. It should be repealed. Thank you very much.
Now, Brian Pomper with the large company perspective.
Thanks, Jim. I'm so glad I get to follow that incredibly engrossing speech. First, let me just say, Stephen, honestly, I salute you and your company for being willing to invest everything that you invested in trying to uphold your invention. So really, everybody, please give me It is no easy feat to take on one of the largest companies that it's ever been created on planet Earth, but you're doing so. So thank you for that. So I serve as the executive director of the Innovation Alliance, and I thought it might be helpful to explain the foundation of the Innovation Alliance. How did we get here to talk about the perspective that my companies have? So what became the American Invents Act that passed in 2011 started in about 2005, 2006. And at that time, the lineup of the fight was really, you've got the pharmaceutical industry on one side, who depends on a small handful of patents, and you've got the high-tech industry on the other side that has a million different patents that they have in their products. And so the high-tech guys wanted to dumb down the value of patents because they were getting sued all the time. And the pharmaceutical industry said, wait a minute, patents are really important to us. We don't want to dumb down the value of patents. The Innovation Alliance companies, Qualcomm, Larry Self, sitting right up here. Is there a $100 thing under here? Qualcomm and others thought, well, wait a minute. We're high-tech companies, but we align really with the pharmaceutical industry because the patents are really important to us. Because our business model is we plow billions of dollars into R&D in order to come up with the coolest new technologies that we can possibly come up with. We patent those, and then we license them as broadly as possible so that they are throughout the American economy. So for us, our products are not routers. They're not cell phones. They are the patents. That's actually what the Innovation Alliance companies are largely. That's how they're making their money, is they're selling their patents. So if you're a company who's only selling your patents because of licensing, you're going to care a lot about how the legal system protects what you're selling. That's, of course, the patent system. And so the Innovation Alliance got very involved in the patent debates way back when. So we are still fighting the good fight, trying to fight the greatest, the biggest companies that the world has ever created. And these companies are very innovative. I'll call them out by name. Cisco, gigantic, innovative company. Apple, huge, incredibly innovative company. All these companies, right? But, Apple sells it's a design company, really, right? It comes up with really cool new technologies. It packages everybody else's stuff into a cool product and then sells it. Google, well, I mean, Google is basically an advertising company, right? Amazon, I mean, it's an online marketplace. They sell other people's stuff. They're very innovative, but they're not patent innovative. For them, patents are a cost. And so they do everything they can and have for the last 15 years, 20 years to try to dumb that down through various legislative options. So I'm going to talk a little bit about, I know Adam started talking about quite a bit about the system and how it's been really messed up because it's not providing the kind of incentives that we need in order for companies to invest the billions of dollars in R&D. I want to talk about it in a way that many of you may have heard me talk about already because I really want to beat this into your heads. I want this to be the narrative. The way I think about patents and our patent system, and maybe this is because of my day job as an international trade lawyer, right? That was my service on Capitol Hill was as a trade counsel. So I think about lots of things in the context of the geostrategic competition with China. I don't know if anybody's heard about that, like anybody focused on that? It just seems to be capturing the imagination of a lot of people right now. I really believe this, that for us, our innovation ecosystem, if we want to compete with China, who, by the way, they can snap their fingers, and $100 billion over here to quantum computing, $100 billion to AI, $100 billion to 5G. They can do that because they're a command and control economy, right? They can just dictate where they want the money to go, and it goes. We don't do that in the United States, right? We're a market economy. We have to have the right suite of policies to make sure that the massive amount of money that is in the private sector is channeled to those areas that are good, both for the United States economically and for our national security. The patent system is a key part of those suite of policies. And I submit to you that we are screwing that up. And if we really want to compete with China, we're never going to be able to compete with them from governments writing checks, right? We passed the CHIPS Act, that's $52 billion. That's nice, I guess, that's good. Hard to pass, $52 billion, a drop in the bucket compared to what the private sector can spend on R&D in all of these areas that we really need to have the United States focus on if 10, 20, 50 years from now, we're still going to be an economic and defense or national security competitor with China. So I believe that very strongly. I really would love everybody to start talking about it in that context, because I do think that makes the patent system relevant to policymakers in a way that they don't necessarily think about it today, right? We come in, we talk about patents and how important this is, and they will agree with us, and I salute the people in this room. Many of you have done yeoman's work going up to Capitol Hill and slowly changing the narrative. I mean, there are many people in this room I know who have been fighting this fight for many years. It feels vastly different today than it did, say, 10 years ago. I think, Laura, it was about 10 years ago that we were at a White House event, 2-day event at the White House about patent trolls. Remember this? Like the director of the National Economic Council leading this 2-day event. Hard to see that happening now. I feel like we've at least beaten the other side back to a point of stasis. But that's not good enough, right? We have got to make sure that we've got the right policies so that our economy, our national security can be secure for the time to come. So that's how I think about these issues. Happy to talk about that further. I'm even done early, Jim. How about that? Thank you.
Spare time. John Schalfly on the policy solutions.
It's a bit intimidating to stand here under a portrait of Senator Everett Dirksen looming down over us. I met Senator Dirksen on my first trip to Washington in 1961. He was a towering, imposing figure with a deep baritone, renowned as an orator. And my mother, Phyllis Schlafly, was on the same platform with Senator Dirksen probably 100 times. And she admired him and studied his oratory and used him in a way to make herself an effective public speaker. So in any case, with that sidelight, I've used up your extra time by telling that little story. But so as we were gathering here, one of our colleagues referred to the patents as a niche. A niche. Well, and I'm sure that those of you who specialize in patents have had the experience of being introduced to somebody, and as anybody, an average person finds out you're a patent expert, their eyes glaze over. But Phyllis, our founder, believed from her childhood, really, when she grew up in the home of her father who designed and patented a rotary engine, she believed that the 1787 convention of our Constitution, and in particular the Patent Clause, was the key, the decisive, and the most important factor that made America a strong, powerful, and rich country. And she never tired of championing inventions, and the clause in our Constitution, which she believed made that all possible. And she brought that subject to a wider audience, I would say, to make it more than a niche. And that's what we try to continue in this annual meeting, now the 7th annual meetings. So, and it was about, though, and after she'd been doing this for a number of years, in the late 90s, I would think, when she became aware that there was an organized campaign to undermine our patent laws in Congress then, and she had done many times before on other issues for which she's better known, organized a coalition of people to stop what was happening. And so she fought hard to stop the move to change our system, our unique system, which first of all, the people who wanted to harmonize America's patent system with that of other countries, she said, no, we're the best, we have the most patents by far. Why change a better system to accommodate a system that isn't as good? So she fought the effort to change from first to invent to first to file. She fought the change to publish patents before the patent was issued. She fought the effort to basically steal patent fees in order to use them for other purposes. She fought the move to convert the patent office to an independent government agency. And so that was the wave of 1998, 99 in Congress. She had a coalition to do that. And then after an interval, there was another wave of bad ideas, which resulted in the American Invents Act in 2011. And once again, she was right there fighting it, fighting the PTAB as it was going through Congress. She had to form a new coalition then because the people who had supported her in the earlier effort had disappeared. So all of that is in the background for part of the reason we're here. Now, she did not live to appreciate that when the next phase moved to the courts, and in particular the Supreme Court, and the decisions, a series of decisions which have had the effect of undermining patent laws, although our survivors, my brother and I, have carried on with filing amicus briefs, including, I believe, we filed an amicus brief in the Centripetal Networks case in the Supreme Court. So we've heard a lot, though, about the eBay decision as being pivotal. Now, I read the eBay decision, and when I read it, it's hard to see what the big deal was, frankly, because that decision in and of itself, it seemed to me, wouldn't have made any significant change. Because nothing in that decision, it seemed to me, changed the reality that a patent is an exclusive right which is granted to an inventor for limited times. I mean, those are the key words. And those words are enough, it seems to me, to call for injunctive relief in almost all cases. So what did it matter that you have to pay lip service to 4 factors? Honestly, I did not see then what the big deal was. But as I've since learned from our mentor, Judge Paul Michel, first of all, the reality is that after that decision, injunctive relief is granted less often. I'm really not sure why, because the Supreme Court didn't say that, and yet that's the reality, that injunctive relief is harder to get. And as Judge Michel also has taught us, you got to consider eBay along with other decisions, all adverse to the rights of inventors, and the upshot of a series of decisions in the last decade is that patents are less valuable. And then when patents are less valuable, it's harder to get financing. And when it's harder to get financing, it's harder for the inventor to really make a go of his invention. And it's easier for the established characters, the established companies, to beat off what they regard as the trolls. The trolls are heroes from the trolls, as we've just learned, those are the people who have the idea and want to license it from the big companies. That's what Edison did, and that's what many inventions in history did from the very beginning. I didn't know about President Washington. That's a very good thing to add to our roster. But in any case, we're here in our organization to defend and protect. Now, Jim gave me the very difficult challenge of what's the solution? Well, go back to the Constitution. What does the Constitution say? And it begins with the words, "The Congress shall have power." Basically, that's it. It's not the courts, it's not the president, or it's not the commissioner of patents, it's the Congress. And so the solution to any of the problems with the patent system is to go to Congress and get remedies and relief. Now, of course, I understand that's easier said than done. And in particular, as we found in our history that to fight off the bad people since the 90s is that the time to be most concerned is when you have a Republican Congress and a Democratic administration. That seems to be the most dangerous moment because that is what has happened. That's what we were in the late 90s. It's what we were in 2011. And I don't know why it is that particular combination is most dangerous to the interests of inventors, but that's been the history to date. And so now we have not quite that. We have, Republicans in one half of the Congress, but in any case, the Congress is where our solution is, and Congress can do anything with respect to patents. And Congress controls the federal courts too. That's another provision of the Constitution. Congress can define the power of federal courts to issue injunctions. Congress can reinforce the fact that the patent owner has a property right, not just, not just a license from the government, and that Congress can defend his property right in court. We thought that's what the law already said until courts found ways to undermine that, but we can go back to Congress and Congress can say, look, this is what we said in 1950 and this is what we mean now. And so that's our challenge, Jim, to, I think, to get remedial legislation in Congress and get it signed by the president to protect the rights of inventors, to renew the promise that George Washington and Thomas Jefferson and Abraham Lincoln, our only president who held a patent, and what it really meant to our country. So thank you.
Thank you, John.
Thank you.
And now we've got 10 minutes for question and answer. There's a mic, right? Okay, great, excellent, thank you. If you've got a question, just raise your hand and they'll bring their mic to you. Before asking your question, if you'd please say your name and the organization you're with, we'd appreciate that.
Can I preemptively say something?
Sure.
All right. I just want to say preemptively very quickly, I appreciate that John mentioned Abraham Lincoln because that was the other anniversary yesterday as well. So May 22nd is a really auspicious date in innovation history because not only is it the anniversary of the Wright brothers receiving their patent in 1906, it's the anniversary of Abraham Lincoln receiving his patent in 1849. As many know, and as John said, he's the only U.S. president to have actually received a patent. So.
And we have a question.
Yeah. Hi, Satya Marar from the Makeda Center. I was interested in the comment that was made about the eBay case and how that's led to a decline in the granting of injunctive relief. Looking at the four-factor test myself, nothing really jumps out at me as sounding particularly unjust. I'm curious to hear from the panel, are there any, which aspects of it have kind of been used by courts, in your view, unjustly to undermine innovation by not granting injunctive relief, or should be granted? Or is it simply a case where requiring further litigation to go and seek that injunctive relief is imposing a cost that's prohibitive?
Everyone's pointing to me. So, so I've written a short article actually on this issue.
That's why we're pointing to you.
That's also like that. That's like the stock phrase of any academic that I've written an article on this. It's called the injunction function: how and why courts secure property rights. But there's a short part of it that talks about eBay a little bit. eBay has been particularly destructive to the ability of patent owners to obtain injunctions, and in fact, it's recognized even outside of patent law as being a very bad decision. Remedies scholars, more broadly, I also teach remedies law, hate eBay, and they don't have a dog in the patent fights. And one of the reasons for that is because there is actually historically no four-factor test for issuing an injunction. That is something that was actually created. So despite the fact that eBay says we're just asking the courts to impose a historical, long-standing four-factor test, there is no historical, long-standing four-factor test. And in creating this four-factor test, they ended up actually mangling the law. So for instance, they split into two separate factors, what is in fact one inquiry, which is irreparable harm and inadequate remedy at law, because those two are actually the same in remedies doctrine. And by the way, this is the doctrine that applies to injunctions for all in violations of all property rights. Land, personal goods. If you ask for specific performance and contract dispute, which is an injunction. And so what then happened? Well, then because there's no four-factor test that's in the case law, then when courts started to look to precedents to apply this four-factor test, because the court says apply this four-factor test, they didn't find anything. And so what happened is courts then shifted to a more explicit policy analysis. And this has been confirmed through empirical studies by an article published by Ryan Holt, now Judge Holt on the Court of Claims, where he found that starting within a few years, all courts started citing to Justice Kennedy's concurrence in eBay. So the concurrence in eBay becomes the eBay opinion, even though that's not the majority opinion. And what's his concurrence? The patent system's broken, there's all these invalid patents, there's these new licensing entities, which is historically untrue, and this is a problem. And so courts took that as the policy message, even though it was only joined by two other justices, as the majority opinion in eBay. And they started to therefore apply this rule that you just essentially can't get an injunction unless you're a manufacturer. But even that has actually proven not to be the rule. So in a study in 2015 showed that even manufacturers had seen a significant reduction in their ability to obtain injunctions under the eBay test in patent law. And so the problem is that the courts got caught up, justices included, in a narrative about the patent system, a false narrative, but it was a narrative nonetheless that then drove them to view the injunctions as an improper remedy for patent infringement.
If I could just, go ahead, Judge.
I just wanted to add to that.
Please.
Oh, thank you. So you're right about everything you said, Adam, but there's two other pieces. One is the fourth factor, which is balancing of the equities as between the parties, is ridiculous if you're looking at a permanent injunction, because by that point, you've already found that there's been infringement of a valid patent. So it made no sense. That was something that they carried over from the preliminary injunction context. So the Supreme Court messed up the law in multiple ways. But in addition, what the Supreme Court also said, and what Justice Kennedy said to great length, is the Federal Circuit was wrong because they wanted to overturn the Federal Circuit. So they said the Federal Circuit was wrong because the Federal Circuit adopts a presumption that you're going to get an injunction. The reality is, if you looked at the Federal Circuit case law, that was not the case. But the Federal Circuit did have essentially applied the normal policy that when you're talking about property rights, that you know, you've got to go a long way to not get an injunction. That doesn't mean it's presumptive, but that it's important that we're dealing with a property right. And because the Supreme Court said over and over and over, a presumption is not appropriate, and the Federal Circuit got it wrong, the district court judges became afraid. And they will tell you that their view was if they granted a permanent injunction in any case, even competitor to competitor case, that they were going to get reversed. It's ridiculous, actually.
I just want to add 5 seconds. What is a patent? Right? It is the right to exclude. If I can't get an order excluding somebody from using my invention, what is a patent? It turns into a compulsory license. And then you forced the patent owner into a negotiation about licensing terms where the patent owner has no leverage to force the infringer to pay anything because they can't stop them from using the patent. That's how I think about it.
Stephen.
So my answer is along his lines, but less lawyerly, and that is, without the injunction, what do you do? You have no forcing function. You have to license. That's the only other thing you can do. We didn't want a license. We wanted to practice our technology, and the 10 other things behind it. But when you do a license with no leverage, what happens is they end up forcing a license on you, not only on that thing, but all your future innovations as well. So you end up becoming what? Some kind of patent licensing company. That's not what we had in mind, and that's not what it seems manifestly unfair.
What they're emphasizing, which is a really key point, which is not unique to patents, is unique to all property rights, is that, and there's a wide misunderstanding about injunctions, that they think injunctions just means stop. And it doesn't. Injunction means if you want to use my property, you have to talk to me. You don't get to coerce me into a compelled transfer of my property where then a government official will determine what the value is that then you pay me. This is the difference for those who went to law school between torts and property. and this is key, because this is what makes the negotiations in the marketplace possible. This is what makes setting the fair market value possible, is one person who has the asset saying, if you want to pay me, if you want to use my asset or access my asset or in any way or transfer it to you, you have to pay me what I'm asking. And because those negotiations won't happen if the person says, well, I can just take it anyway, and we'll then go through either an administrative tribunal or a court to determine what a government official will determine I should pay you. And that's not the free market.
Thanks for that question. Another question.
Excellent.
I have more of a comment, and you can comment on it. But one of the frustrating things for me sitting here listening to that last.
Who are you,
I'm Gene,
sir?
I'm sorry, I assume everybody knows me. I'm Gene Quinn from IP Watchdog. And thanks for having me, Jim. But in listening to that, go back and forth with everybody said, we all agree with that. But the frustrating thing for me is why are we even talking about this on their terms, right? What's wrong with there having been a presumption? You were found to infringe. You stole the technology. And all the injunction says is what the patent itself says, is don't use because this person has an exclusive right. And really, the only remedy is the patent owner gets to go to the front of the line if there's continued infringement, to go back to the district court to get resolution of that, rather than to go back in the line and have to re-sue all over again. We're fighting this war of attrition with a wasting asset, and we're losing. And I think it's high time that we take the fight to them and stand up and say, yes, you're right. There should be a presumption, and explain why. And just get in their face, because that's what they do to us, and they win. And that's the New Jersey talking.
Anybody got a New Jersey response or otherwise?
Well, I agree, but that it's because actually the historical law is that it was framed as a rebuttable presumption. And by the way, this wasn't, again, unique to patent law. This was true of all property rights, because this is just the general idea of how you got injunctions in the law, was that you got an injunction to stop continuing behavior going forward. Damages were what happened in the past. So the way to stop someone from doing something in the future is you get an injunction. And so the key requirements for getting an injunction is it's continuing or it's willful, because if it's willful, they're showing they're willing to do it again. That's what got you into equity courts, and that's what got you the injunction. That's true for land just as much as patents. In fact, so for a lot of people don't realize, a one-off trespass, like one person just kind of mistakenly walking your land, doesn't get you an injunction. That gets you damages, because trespass was just was an action at law for damages. And so you got to get an equity court by showing, well, they did it willfully, or they've been doing it repeatedly. Well, patent infringement is repeated infringement, because it's commercial. They're making it, they're manufacturing, or it's willful. They know about your patent in the predatory infringement context. And so this is why historically Chief Justice Roberts noted in his concurrence in eBay, patent owners almost always got injunctions. And that's true, actually. I'm doing a big empirical study to show that, to confirm that point, but that it's actually true and right, because it was a rebuttable presumption. You got the presumption, you got the injunction, and then it fell upon the defendant to try to rebut it. In equity, that's then where they would argue the balancing of the harms and the other types of issues that came up that they implemented in preliminary injunctions as well. But you're exactly right. I think we should, restoring the presumption. I think the allegation in against Federal Circuit was that it was automatic, not, that it wasn't even a presumption. It was automatic. They didn't even make any inquiries, and that was pure rhetoric. That was pure, a narrative that was framed around their actual cases. I think if you actually looked at their cases, and Judge O'Malley, you can confirm if I'm wrong in this, is that no, they applied the long-standing historical practice of a presumption of an injunction. If it then the defendant could rebut it with the evidence that had been historically admitted in all cases, is how you rebutted an injunction. Yeah, and I agree with you. That's what we should restore. And Congress recognizes this because they restored it in the trademark context. So when the courts extended eBay to trademark law, trademark owners rightly freaked out because they said, oh my God, we're not going to be able to get injunctions to stop trademark infringement. And by the way, if you can't stop someone else's use of your trademark, then that really it's gone, right? The whole point is that you have exclusive use over this mark. And so they adopted a one-sentence amendment in the Trademark Modernization Act in 2021 that said, on a finding of trademark infringement, the trademark owner has a rebuttable presumption of irreparable harm, and that everyone recognized that as fixing this solution. And I think we could probably do something very similar in patent law as well. And I agree, we should take the fight to them.
Well, thank you, panel. Well, this has been an excellent discussion. We went more in depth on the one question, but that was really tremendous. So thank you all. I want to invite you in a few minutes to join us upstairs on the third floor for the reception at 5:30. And on behalf of Ed Martin and Eagle Forum Education Legal Defense Fund, we really appreciate your being here.